Welcome, everyone. My name is Laverne Jacobs. I'm a law professor and the Associate Dean, Research and Graduate Studies at the University of Windsor Faculty of Law. I'm also a member of the Tribunal Watch Ontario Policy and Advisory Committees. I'm delighted that you're able to join us for this webinar on Tribunal Independence and Impartiality, part of the webinar series called Principles for Adjudicative Tribunals and Administrative Justice. This webinar series is being co-hosted by Windsor Law and Tribunal Watch Ontario. Before we begin, let us take a moment to acknowledge the traditional custodians of the land. Windsor Law sits on the traditional territory of the Three Fires Confederacy of First Nations, which includes the Ojibwe, the Ottawa, and the Potawatomi. We cast this acknowledgement broadly into the digital sphere in which we have gathered today and extend our respects to the traditional territories where you are based as well, and to the knowledge keepers of the land where you are located. We are grateful to be here. Now is also a good moment to mention two logistical notes before we begin. First, today's session, which is scheduled for an hour and a half, is being recorded. We will make the recording available along with an edited transcript as soon as we can after the event. During the event, we are using the Zoom transcript function, which we recognize sometimes picks up errors. And so we will edit and correct the transcript to make sure that it is available along with the recording. Second, throughout today's session, if you have a question for the panelists, please feel free to place your question into the Q&A box. We will have a question and answer period in the last segment of the event, and we'll take questions from the Q&A chat box. We apologize in advance, but we may not be able to respond to all questions, but we sincerely and enthusiastically welcome feedback. So please don't hesitate to place your questions and comments in the Q&A. Before I turn to an introduction of the substantive topic and an introduction of our fantastic guest speakers, let me just say a few words about this webinar initiative. Windsor Law has teamed up with Tribunal Watch Ontario to hold these community discussions on principles of administrative justice. The effort, in large part, is related to a document created by Tribunal Watch Ontario called the Adjudicative Tribunal Justice System Statement of Principles and Commentary. This statement of principles was just released this month in May. It sets out principles that should be followed in order to ensure, enhance, and develop the rule of law in Ontario's adjudicative tribunal justice system. It recognizes four principal attributes necessary to safeguard public confidence in the administrative justice system. These four attributes are independence, impartiality, expertise, and competence. The statement also emphasizes that these attributes should always be respected by governments charged with adjudicative tribunal design and administration. We're using these principles as the starting point of a discussion about how to improve and reform the adjudicative justice system in Ontario. We have with us today Brian Cook from Tribunal Watch Ontario, and I've invited him to say a few words about Tribunal Watch. So let me turn it over to you, Brian.
Thanks so much, Laverne. Tribunal Watch Ontario is a public interest organization. Our mission is to monitor Ontario's adjudicative tribunal justice system, advocate for adjudicative independence, and promote access to justice. Tribunal Watch was formed in early 2020 when a group of senior academics, practitioners, former advocates, and former tribunal members came together out of concern about what was happening to Ontario's tribunals. We issued a statement of concern which focused on the alarming depletion of adjudicators appointed to key tribunals. This was caused mostly by the government's apparent refusal to reappoint experienced adjudicators and a failure to appoint new members. Since then, there have been some new appointments, and many have been very fine adjudicators have been appointed. But most tribunals still have a complement well below pre-2018 levels. And there is definitely an ongoing concern that some new appointments lack adjudicative and subject matter expertise. And that's obviously especially problematic when tribunals have lost the most experienced adjudicators. Today is about looking to the future, towards a new modernized system, and thinking and talking about what we need to have in order to have a fully functioning, just, and expert adjudicative tribunal system. We are so grateful to Professor Jacobs and her team, and to the panel who have so generously come together today to share their insights. And I think we're all looking forward to a great session. Thanks.
Thank you, Brian. And for everyone's information, a link to the Statement of Principles was one of the links sent to you this morning from Law Events. So finally, I want to note that in every webinar in our series, we will be addressing the principle that we're discussing from 4 different and key perspectives. These perspectives are the doctrinal law, what the case law currently has to say about the principle in question. The second perspective is that of those who use the tribunal. So we bring a generalized view to the principle from the angle of tribunal users by hearing from leaders in the clinic community who discuss challenges that currently exist for the principle under discussion. The third perspective is that of the tribunal as an institution. And here again, we draw from leaders in the administrative justice community who have been tribunal chairs for their reflections. And fourthly, we examine the principle from the perspective of equity, diversity, and inclusion. Here we bring scholars and our people with lived experience to discuss and analyze the ways in which each administrative justice principle could be strengthened when it comes to fostering equity, diversity, and inclusion in the administrative state. We're of the opinion that equity, diversity, and inclusion should not be seen as add-ons, but should be relevant to everything that is done in the adjudicative tribunal context. So let me now move right into the heart of today's discussion by giving an introduction to the topic of today's webinar. I have been writing about and studying tribunal independence and impartiality as a scholar for several years, and it's events like these that energize me. They energize me because they illustrate the many ways in which independence and impartiality are important principles on the ground, within the tribunal itself, for the broader administrative justice community, and for the public. Tribunal independence is said to be a cornerstone of the administrative justice system. The purpose of independence is to serve as a stepping stone to ensure that the tribunal adjudicators and tribunals themselves will make decisions in an impartial manner based only on the facts, law, and their conscience. Tribunal independence is based on concepts derived from judicial independence. When we speak of tribunal independence, we are normally referring to an individual decision maker or tribunal's ability to make decisions without inappropriate interference. Inappropriate interference can come from government, especially when we're talking about the tribunal as an institution. When we're talking about individual decision makers, inappropriate interference may come from government, the chair, or other decision makers, political lobbying, and other places. Normally, when we speak of independence, we are dealing with 4 guarantees: security of tenure, financial security, administrative independence, which is also sometimes called institutional control, and finally, adjudicative independence, used by adjudicators in deciding discrete cases. The guarantees of independence that mostly come into play in today's webinar deal with the adjudicative independence of individual adjudicators and with the institutional control of the tribunal itself. There are other elements of independence, though, such as security of tenure, that are relevant and will likely enter into today's conversations as well. So I now have the distinct pleasure of introducing each of our fantastic guests who bring fantastic knowledge and insight to our conversations today. These introductions are brief, and I encourage you to take a look at the much more fulsome bios provided on the speaker bio webpage. I'll start with Professor Paul Daly. Professor Paul Daly holds the University Research Chair in Administrative Law and Governance at the University of Ottawa and is also an Associate Professor at the University of Ottawa's Faculty of Law. He will be speaking to us from a doctrinal law perspective. Marian Overholt is the Executive Director of Community Legal Aid and Legal Assistance Windsor, located at Windsor Law. She has practiced law for 38 years and appeared before a variety of administrative tribunals and courts. Marian will be speaking to us from a tribunal user perspective. Gary Yee has been appointed as the chair of 4 tribunals over a 25-year period. He has also worked extensively as a consultant for a variety of tribunals. He is a member of the steering committee of Tribunal Watch Ontario and has received a number of awards for his contributions to administrative justice. Gary will be speaking to us from the perspective of tribunals as institutions. I will be your moderator for today and will also be contributing reflections on the relationship between tribunal independence and impartiality, and equity, diversity, and inclusion. Each of our speakers was asked to prepare a blog post discussing the principles of tribunal independence and impartiality and the challenges that they see from their work and experience. These blog posts are available on the internet. A link was sent to you last week and this morning as well. I'd like to first start by inviting each of our speakers to present a brief overview of the challenges that they have observed. So to each of the panelists, I ask you this question. What major challenges do you currently see with the concepts of independence and impartiality from your perspective? And I'd like to start with Professor Paul Daly, who will speak to us about the challenges that exist for the concepts of independence and impartiality in Canadian case law.
Well, thank you very much, Professor Jacobs, for having us, and thank you to all of the attendees. It's always a relief to see that an issue such as tribunal independence and impartiality is of such great interest to so many members of the legal community. As we know, as members of that community and people interested in administrative law, for many citizens, their rights and obligations are determined by tribunals, not by courts. And these are the last points of contact that many people have with the legal system. And therefore, the conditions of tribunal independence and impartiality are of general importance to all Canadians. And this is a very important topic, and Tribunal Watch Ontario is doing very important and in some ways groundbreaking work on these issues. So briefly then to talk about the challenges in terms of independence. I suppose there are three aspects here to disaggregate. One is structural or institutional independence. The second is the adjudicative independence of particular administrative tribunal members. And the third is impartiality. I'll start with impartiality because I think it's the least controversial. The test for impartiality, as we all know, was set out by Justice de Grandpré in his dissenting reasons in the National Energy Board case in the mid to late 1970s. And you have to ask whether a reasonable, well-informed person thinking the matter through would think that a particular member was unable to adjudicate fairly because of variety of things, their past involvement with one of the parties, prior statements, and so on. What's interesting about the law on impartiality is that it is highly context sensitive, and it applies in a much more moderated manner to administrative tribunal members than to judges. And administrative tribunal members do have some leeway in terms of relying on their pre-existing expertise and knowledge in exercising their functions. Even on at the judicial level, there has been a significant moderation in recent decades of the standards of impartiality, and that I think is all to the good. And there's scope for tribunal members to be involved in organizations like this one and in other organizations without creating an apprehension that they may be biased in a particular way in a particular case. If we turn to structural independence, I think this is where I would perceive the greatest difficulties for the administrative tribunal community, and by extension for the Canadians whose rights and obligations are determined by these tribunals. Whereas the law of procedural fairness and the law of substantive review in Canada impose demanding requirements on administrative decision makers, the law of structural tribunal independence, security of tenure, financial security, administrative autonomy is comparatively weaker. The Supreme Court's decision in Ocean Port Hotel in 2001 reduced the effect that the common law might have in terms of enhancing tribunal independence to virtually nothing, and the appellate jurisprudence since then has not extended the concept of tribunal independence in any meaningful way. We are stuck in the position set out by the Supreme Court in 2001 that administrative tribunals, even when they're acting as court substitutes, do not have any constitutional status and do not have any constitutional protection. Even when we get to cases where tribunals are dealing with issues relating to Section 7 of the Charter, the life, liberty, and security of the person, or to matters protected by the Canadian Bill of Rights, here the requirements of independence are said to be context sensitive and do not approach judicial guarantees of independence. So in terms of financial security, security of tenure, that relates to reappointments, of course, which is a significant pressure point in many tribunals, and to administrative autonomy, again, another significant pressure point. There's little scope for meaningful judicial reform of the law. You can contrast this, and this is a major challenge, and I think the statement of principles is very useful, is going to be very useful in fostering certainly political debate about potential reforms to tribunal justice, and that is probably where the reforms are going to have to be made. Lastly, there's a striking contrast between the approach that the Supreme Court and appellate courts have taken to tribunal independence as a structural matter, an institutional matter, and the level of independence that individual adjudicators have, their protection, as it were, from influence by tribunal chairs and other members. Here, the protections are much more robust. The common law will intervene to ensure that where a tribunal chair is exercising inappropriate pressure on a member, that this is unlawful. And so, whereas in Ocean Port Hotel, the structural independence as part of the common law was minimized, if not obliterated entirely, independence at the individual adjudicator level continues to have some teeth. And so when the statement of principles sets out the importance of individual adjudicative independence, there at least there is prospect for judicial enforcement. Thank you very much.
Thank you so much, Professor Daly. That's very interesting. I'd like to turn next to Marion. As a practitioner in the clinic system, what challenges do you see with the principle of tribunal independence and impartiality on the ground day to day?
Thank you so much. No, it's my pleasure to be part of the panel today and really appreciate Tribunal Watch's initiative in not only creating the statement of principles, but organizing these webinars, because I do think it's really important. And I really want to echo the comments of Paul in that regard. I think in terms of this issue of tribunal independence and impartiality, I really want to focus my comments on what Paul's identified as that structural independence, because that is the area that I think we all agree the tribunals are most vulnerable. I mean, they're created by government and they can be taken apart by government, right? And so that concern about how viable the tribunal is going to be as an independent adjudicative body is a real concern. I think when we look, in recent history, we see what happened with the Criminal Injuries Compensation Board when the government of the day decided to totally change that process from being an administrative tribunal to an administrative process with no hearing, no adjudicative function. That decision back in 2019 had to send a chill through the administrative tribunals in Ontario. And certainly as an organization that was representing clients before the Criminal Injuries Compensation Board, it made those of us within the clinic system very concerned not only about the changes for people who previously would have been able to qualify for benefits under that system, but also made us look at the vulnerability of the other tribunals that we appear in front of and what it would mean for our clients. Because within the clinic system of Ontario, we're representing clients who are low income, marginalized people whose often claim is against the government. So having independent tribunals that are created by government who are also making decisions often against government, we need to be in a position where we can say to our clients, no, this tribunal is independent and the government cannot influence their decisions. So, in contrast to those kind of, overt decisions like canceling the board, government interference within tribunal can also happen in a number of very subtle ways, but also have incredible impact on the tribunals. And, I think the statement of principle talks about the importance of providing for adequate staffing, looking at issues of restrictive funding, questioning the unreliability of the appointments process, because all those factors impact the independence of the tribunal and its ability to conduct its work. And I think particularly now, as we're in this state of COVID and we see Tribunals Ontario has adopted a policy of digital first, that access to justice issue is really highlighted. And so the question becomes, is there still an opportunity to have a fair hearing before the tribunal when parties do not have equal access to the technology or knowledge of the technology in order to be able to participate in their own hearing? So I think those kind of challenges are really forefront, and we have to take the time to really dissect those issues and ensure that fairness is resulting, and that is a reflection of the independence of the tribunal. Because without that element of fairness and the ability of the tribunal to hold independent hearings and give people the opportunity to participate, then we're undermining that the administration of justice, we're undermining the rule of law, which is a concept, a foundational pillar that the government has every interest in maintaining. And so in maintaining those, the issue of independence of tribunal, they're maintaining, people's ability to support and engage effectively within our administrative tribunals and within the rule of law. That would be my comment. Thank you.
Thank you so much, Marion. That's so interesting. And I'll turn next to Gary Yee. Gary, you've been the chair of 4 tribunals and have extensive experience running adjudicative tribunals. What challenges have you seen in your work?
Well, first of all, thanks again, Laverne, and it's just great to be a part of a session like this. Paul said it's a relief to see so many people interested in independence issues. I think that's one of the major challenges, that we even have to spend our time and resources talking about independence. Still having to try to convince or pressure governments to accept that tribunals need independence and that we're fulfilling a judicial function. We're not like operational agencies or advisory boards and investigation commissions. In my early years in the tribunal world, back in the 90s and even before my time, there was lots of talk about independence in meetings, conferences, papers, so on. But then later, the tribunal system started maturing. And especially in Ontario, we were able to have almost like the luxury of talking about other things, accountability, performance measurement, things like that. And I say especially in Ontario, because we really had over a decade of consistent, depoliticized approach to tribunals. A second major challenge from the tribunal's perspective is that so much of the things that go on about adjudicative independence operates behind the scenes. So you can have lots of policies, words, you can have laws, right? that can promote the importance, the requirement of independence, but the actual practices by a government or within a tribunal by a chair, and that can easily endanger adjudicative independence for the decision makers in so many ways. I'll just mention a couple of examples in my time here. I worked 10 years at the Immigration Refugee Board. And, you know, in 2009, then Immigration Minister Jason Kenney made public statements that expressed concerns about the, you know, too many false refugee claims from Romas in the Czech Republic. So, you know, here's the same minister who was in charge of appointing and reappointing Immigration and Refugee Board members. There were challenges to the federal court that failed, you know, challenges on the basis of institutional bias. And, you know, I would take issue with some of the approach by the court there, but we don't have time to get into it. I suppose if you granted those challenges, you know, what happens? You know, who's going to decide those cases? So, you know, practically, there were major obstacles involved there. And then another example would be more recent. If we look at what has happened after the recent elections, both federally and in Ontario, you know, those of us in the tribunal world, we see this happening with every election where the party changes. Sometimes we see a politicization happening even when there's just a new premier, same party. Bits of that happened even when Kathleen Wynne came in. You know, it's just, there's just too much that changes for tribunals because of the election cycle, because of who's the governing party. And so you see many experienced tribunal members, chairs, vice chairs, who are not reappointed. And, you know, they may not have had any connections to the previous governing party. They may be really good, even if they had connections, right? Because being active in partisan politics is not in itself a disqualification, but serious concerns are raised when there's a pattern of appointees to leadership positions who have obvious party connections. And that's what we saw a lot of in Ontario last year. So we really need to have systems in place that will stop this politicization, or, you know, it's the appearance of politicization. That's bad enough. We don't need actual politicization. And it is actually reappointments that will affect adjudicative independence far more than the initial appointments. The initial appointments may give you a slightly different or a vastly different composition. That in itself does not necessarily infringe adjudicative independence. What happens is when you have good members who are recommended by the chair, and everyone knows they're good members and have been recommended, and they're not reappointed. When that happens, an adjudicative chill spreads across the tribunal. And, you know, there's lots of speculation. Why did that person not get reappointed? No one ever knows. You know, those are cabinet things, minister things, political things. But people speculate, you know, was it that member's, you know, maybe controversial decision? Is that member seen as too hard or too soft on some of the key issues? No one knows. So what do you do when you are a member, a full-time member, and maybe perhaps the only source of income in your family, and you're coming up on maybe a 3-year reappointment, maybe a 5-year reappointment, and you have a controversial decision coming up that maybe the minister has spoken out about, or the government is the party. You know, that's where it really hits the ground when you see the potential impact of politicizing tribunals.
Thank you, Gary. And thank you especially for drawing the connection between appointments, reappointments, and, you know, I think you've rightfully placed an emphasis on reappointments and the entire process of protecting independence. I think that, you know, the reflections about the time period when we had kind of the golden years and didn't have to think about these foundational issues of independence are very relevant ones. And I think that although we talk about Tribunal Independence as being there to provide protection for the public, and not really about the adjudicator themselves. I think that piece where we actually consider the impact on the adjudicators is very important as well. So thank you for that. So let me add a few observations about what I've seen as a scholar of administrative law and human rights, inclusion, and diversity in answering this question as well. So I'd like to first outline the reasons why we need equity, diversity, and inclusion in administrative justice, and then move into the challenges that I currently see. And to do this, I'm going to speak to some extent about theory and some theoretical writing that I think is quite relevant. So there are at least 4 advantages to having equity, diversity, and inclusion. I would argue there are many more, but for the interest of time, I'll focus on 4. And these advantages to decision making have been identified in Canada over the past 25 to 30 years. They have arisen primarily with respect to judicial decision making, but I would argue that they apply with equal or greater force within the administrative justice system as well. So the first advantage is having a representative selection of decision makers. Usually this is referred to in judicial contexts as having diversity on the bench. A second advantage deals with the possibilities of better understanding social context. The third deals with the possibility of improving credibility assessments. And the fourth advantage of having EDI in decision making is the ability to enrich the concept of impartiality through dialogue. So let me say a few words about each of these 4 advantages before moving on to the challenges that I currently see with respect to ensuring that principles of tribunal independence and impartiality work in tandem with the value of inclusion. And despite the fact that these ideas have arisen in the judicial context, as I've said, given the importance of the administrative justice system to most people in Ontario, in Canada, who will encounter the administrative justice system, likely before they encounter a court, or may encounter the administrative justice system and never encounter a court, it's certainly a principle and primordial of primordial value. So turning to the first advantage of having a representative selection of decision makers, we've certainly witnessed in current times and continue to witness significant social unrest that signals to us inequality of various sorts, ableist systems, colonialist damage, and other forms of structural and systemic barriers. It's clear that hearing the voices of people from communities that have suffered these harms should help to help the broader society to break down these systemic barriers. The second advantage, the possibilities of better understanding social context. These possibilities have been illustrated in comments made by people such as the Honorable Mariko Matsu and through the Supreme Court of Canada decision in RDS, both from the 1990s. The now retired Honorable Mariko Matsu was the first woman of East Asian descent to be appointed a judge in Canada. And she stated in extrajudicial writing that lack of experience of the daily lives of working class people and the circumstances and functioning of specifically working class institutions, such as trade unions, deprives those who do not have that experience of potentially relevant information on which to make impartial judgments. Similarly, in 1997, the Supreme Court of Canada decision in RDS, dealing with a reference to the social conditions in Nova Scotia for Black youth made by a Black judge, has shown us that permissible circumstances for incorporating diversity involve instances where the adjudicator is not primarily relying on their personal knowledge of the circumstances to make their decision, but rather where assessments are made on fact, law, and conscience, and where an adjudicator's understandings of social context may be helpful to deepen an understanding of the facts and law. The third advantage, the possibility of improving credibility assessments. Here I draw on another quote from the Honorable Mariko Matsu, who stated that people who have encountered racial or ethnic prejudice will be better able to identify its various manifestations than those who have not. To the extent that gender, class, race, or ethnicity affects one's behavior on the stand, direct experience will also help judges to interpret a witness's demeanor, for instance, to assess credibility. These words have been supplemented by at least one recent study that suggests that the lived experience of adjudicators may assist with asking appropriate questions about findings. And finally, improving impartiality through dialogue is the fourth advantage I've identified relating to inclusion and decision-making. I speak about this advantage at more length in my blog post, but the basic idea is one from Professor Jennifer Nadelsky. It's the idea that a stronger version of impartiality comes from an enlargement of the mind, where decision makers picture or find themselves in conversation with others who come from different backgrounds and lived experiences. A decision maker going through the exercise of asking what it would take to convince other decision makers from different lived experiences and standpoints about their conclusions helps them to achieve a version of impartiality that's not locked in one, usually dominant perspective. So those are some of the advantages to having diversity and inclusion in adjudicative decision making. What are the current challenges that I see in infusing inclusion into the administrative justice system, and particularly with respect to independence and impartiality? The major challenges that I currently see appear in four places. The first is in the process of adjudication. So bringing diversity and inclusion into the process of adjudication can have several advantages. At the same time, it requires us in the administrative justice community broadly and in individual tribunals more narrowly to spend some time contemplating the concept of impartiality and thinking about how impartiality can be enriched by the vantage points brought by diversity and inclusion. This is an important challenge. It's not an insurmountable one, but it is one that takes time and care. I also see challenges in non-adjudicative institutional development. Tribunals can and should use their institutional independence to foster inclusion by making institutional decisions through an inclusive lens. So at the very least, assuring that all decisions are anti-racist, anti-ableist, anti-colonialist, etc. An adjudicative tribunal is not just decision makers deciding matters of law, as I think we all know. Every tribunal has an institutional aspect to its existence, where members come together to share ideas, think about the tribunal's overall direction, think about improving efficiency, such as how to reduce delays in hearings and backlogs, and to consider new and emerging directions in the statutes that the tribunal administers. So ensuring diversity and inclusion is not just a matter of recognizing inclusion in the adjudicative space, it's also necessary to foster an inclusive collegial culture within the tribunal itself. So diversity and inclusion, I'll just say one more thing, should be found not just in the decision makers, but also among frontline and other staff. There are two more places where I see challenges that we are addressing, and I think could be further addressed. I think that every government needs to ensure that diversity is existent in tribunal appointments, working in collaboration with tribunal chairs and advisory committees on EDI. And advisory committees could be usefully developed to assist with recruiting interested applicants from diverse backgrounds. And fourthly and lastly, adjudicative tribunals should use their institutional independence, their administrative independence or institutional control to ensure that they are relevant and accessible to their diverse body of users. So those are the comments and thoughts that I have on how we can bring together most effectively independence and partiality along with the value of inclusion. So I thank the guest panelists for your comments and your contributions to the first segment of our discussion. I'd like to move now to a segment where we look a bit more closely to how the issues identified in the last round of commentary should be addressed, and also whether the Tribunal Watch Statement of Principles addresses the challenges we've seen. So let me start again with the doctrinal law perspective and turn to Professor Daly. I think you have started to address this, but you may have further interventions. So how should the issues that you've identified relating to tribunal independence and impartiality be addressed? And does the Tribunal Watch Statement of Principles provide enough scope to address them adequately?
Well, I think there's certainly enough scope to address them, but some of these questions are quite difficult. If we think of, let's make a distinction between impartiality and independence at the individual level, and independence and impartiality at the institutional level. At the individual level, it's often very difficult for an individual who's on the receiving end of a tribunal decision to know whether or not the adjudicator really was biased or really was independent. In terms of the rule against bias, there are limits to what the judicial process allows you to unearth in terms of the predispositions of the tribunal member. You may never know if the tribunal member really did approach your matter with an open mind. And the way the test for bias is currently formulated, it looks at perceptions. The courts, there have been cases in the federal courts where applicants have adduced statistical evidence that a particular adjudicator never grants or very rarely grants refugee status relative to their colleagues. But the courts have held in Canada, and this is true in Ireland and Australia as well, that this evidence, this statistical evidence on its own, is not enough to demonstrate bias in an individual case. And that makes it very difficult to demonstrate bias. And that's in a situation where you do have a body of evidence which might lead you to think that there was a predisposition in a particular way. And in many cases, you're never going to have anything like that body of evidence. That's a significant difficulty. Then when we turn to adjudicative independence, what goes on behind the scenes in tribunals is shrouded by deliberative secrecy. And deliberative secrecy here is something of a double-edged sword. I think most tribunal members are probably quite happy that their internal deliberations are shielded from public view. This might be a situation where too much more transparency is not necessarily a good thing. And certainly when I'm making decisions at the tribunal I sit on, and I discuss matters with colleagues, I look for insights. I'm not sure I'd be comfortable with those conversations being made public and being open to public scrutiny. But as long as these are not, as long as deliberative secrecy applies, if a tribunal chair is pressuring, or if legal services are pressuring a member to write a decision in a particular way, well, we're never going to know about it. It's difficult for me to see how you would do away with the deliberative secrecy that tribunal members need to go about their business in order to illuminate those more problematic areas. Perhaps the answer is that in terms of peer review internally, in terms of reasons review internally, there should be an obligation, statutory or perhaps there be a case where a clever judge can say this. Maybe there should be a requirement, statutory requirement, or a common law requirement for policies relating to peer review and internal review to be published and to be publicly available. This would help somewhat. It would preserve deliberative secrecy for tribunal members' internal discussions, and also give some peace of mind in terms of the likelihood of pressure being brought to bear on individual members. If we move to the institutional level, again, as Gary says, much of the difficulty here is that a great deal goes on behind the scenes in terms of reappointments, for example, and even those in the tribunal don't necessarily know why Gary or Paul or Marion isn't there anymore, and that's problematic. At the judicial level, in terms of the prospects for reform of this situation, the prospects are pretty bleak. I saw someone in the chat suggesting that, I mean, how can a tribunal be independent if it's locked into discriminatory policies? But I think, with respect, and I think there's maybe a category mistake at play here, and it's a category mistake, I think, which you can find in the Supreme Court's decision in Ocean Port Hotel as well. And that is, we can agree that tribunals are there to implement government policy without also saying that tribunals should not have any legally guaranteed independence, or constitutionally or legally guaranteed independence. You can be an instrument of policy, but also be independent in terms of your security of tenure and your administrative autonomy and your financial security. I don't think one necessarily follows from the other. But this category mistake is embedded in the Supreme Court's jurisprudence, and unless the Supreme Court agrees to hear a case, it has to be a plausible case which gets to the at least to the appeal level, it's not going to revisit this, which is unfortunate. And so we're thrown back on the political process to give meaningful effect to tribunal independence at the institutional level. And here, you have something of the fox being asked to guard the hen house. I mean, politicians seem to like, of all stripes, seem to like patronage appointments. They seem to like making statements about what tribunals should do without necessarily thinking about the effects their words will have on members who are worried about the prospects for reappointment. And so we have the fox guarding the hen house, and we have to try and find a way of convincing the fox to do that job without giving into the temptation of lapsing into old habits. That's not easy, but we have seen over the years, you do see attorneys general in various places and at various times who are committed to tribunal independence, and their legislation and their practices can go a long way to supporting tribunal independence. And so even if the courts can't be persuaded to intervene, political actors might be. And I think the statement of principles is a very neat summary of the importance of tribunal independence and a call to action at the political level in terms of achieving it.
Thank you so much, Paul. And yes, I agree with you with the challenges that it's almost like a catch-22 in many of these situations, right? The Supreme Court, will they actually rehear something relating to the ocean port issues? I think that fundamentally, perhaps what you might be pointing at, what I would suggest is that we need a bit of a culture change. We need to find a way to foster this culture change so that our understandings of how tribunals function and how independence itself, the very concept should function, is something that is understood differently. So thank you for that. Marion, from your perspective, how do you believe the issues that you've identified relating to tribunal independence and impartiality should be addressed? And does the Tribunal Watch Statement of Principles on Independence and Impartiality provide enough scope to address these challenges? So from your perspective, representing tribunal users.
Right, okay. Thanks so much, Laverne. So I think it is a very challenging issue to grapple with, because just following up on what Paul is saying in terms of member independence and how does the individual tribunal member approach their task as a user, the question always becomes, did I receive a fair hearing? Did I have an opportunity to present my case? Did I understand the tribunal was listening to my testimony? Did they understand my situation and have some idea of what my experience was, which I think speaks to the points that you were raising, Laverne, in terms of equity and diversity. part of the support that we can have for individual tribunal members depends on the composition of the tribunal itself and what kind of discussions are happening amongst tribunal members and how they understand the lived experience of the people who are attending before them. Because if it's clear to that person who is, a party to the proceedings that the tribunal doesn't understand their situation or doesn't respect their, what has happened to them, then their investment in that system is going to be minimal, and their willingness to use the system is going to be adversely affected because they're going to a place where they're not going to be understood, right? And so that gets back to my earlier point was, if we see the rule of law as an important pillar of our democracy, then we want to have an adjudicative system that people believe in, that's going to be reliable, that's going to be fair, and therefore has to be independent of government. So I think it always comes back to that role. What role does government want to play with this, right? And so when we look at accountability, how is the government accountable to the tribunal for the system that they have created, right? And I think that becomes a huge question. And there have been, as Paul says, attorney generals in the past that have recognized their role in terms of creating an independent system and really protecting it. And so I think when we look at situations, for example, when the Auditor General does a review of like a couple of years ago, they looked at the Social Benefits Tribunal and criticized the tribunal for the number of successful disability appeals that had been heard by the tribunal. That was a missed opportunity for the government. They could have responded and said, part of what's happening here is the tribunal is meeting with the individual person, and that person now has an opportunity to explain how their medical conditions are affecting their ability to engage in their activities of daily living. So they had more information than the administrative process that happened at the Disability Adjudication Unit, where they reviewed a paper application and maybe some evidence. So the Auditor General, when they're looking at reviewing the expenses of different ministries, it's always a cost question for them. And so they were criticizing the tribunal, saying you're spending too much money by granting all these people, but they're not looking at the greater implications of overall government budgets, where people being on social assistance at a greater level of income means they're more secure, and we're addressing the social determinants of health. So there is an opportunity for the government to explain the context of the tribunal, that it is independent. But what we saw in the response from the government is just an acknowledgement saying the tribunal is independent, but we are going to address this issue, right? And so that doesn't encourage confidence in the system and a belief that independence is going to be respected. And I think as a result, when the government does not take those opportunities, then it becomes a situation where we're in now, where who else can step up to be a champion for the tribunals? And I think partly I would answer that question in relation to the lawyers that appear before the tribunal that are part of the system certainly have professional obligations to uphold the administration of justice. So if we're not speaking out in favor of the independence of tribunals, then we're not discharging that professional responsibility. And I think these type of forums and these discussions are a way that we can raise this issue up and affirm the importance of independence. And again, provide the government with an opportunity to acknowledge that independence and do so in legislation, so that there are greater protections for the challenges that we've been talking about today.
Thank you so much, Marian. Very, I think that's so insightful. I'm just still, I'm grasped by the idea that you raised, really, dealing with the interaction with individuals before the tribunal and making sure that their matters are given close attention. And it seems to me that part of the the way out of this conundrum is to think about ways in which administrative tribunals can, use their institutional independence, in ways that are beneficial to the individual applicants and individual, litigants before them. So, maybe a hearing is helpful, but maybe before you even get to the hearing stage, there's something that can be done. And I think that your example is a wonderful one. It's something that I've seen and thought about in my research and as a tribunal member. So thank you. I'm going to move now to Gary. So Gary, from your deep experience as a tribunal chair and as an advisor and consultant in the administrative justice system, how do you think the issues that you've raised should be addressed, or any of the issues that we've been discussing here today?
Yeah, actually, I like that last point you mentioned about Marion's point, how tribunals could try creative things internally and use some of their powers to mitigate really some of the damage that can be caused when there is pressure on our independence. If we look at it structurally, certainly legislation is one way, but we've seen how legislation is not enough in many of these situations. We have this great Tribunals Act, ADIGA, and it has language in Section 14. It can be tightened up, it can be stronger, but it was groundbreaking when it happened 10 years ago. But that hasn't protected Ontario tribunals, from being affected by a change in government or having OIC decisions, appear to be politicized. So we do need stronger legislation. It can help, but we need a lot of reform in so many other areas. We need systems, right? Systems that require transparency, that allow for review, that require accountability. And that's not just about appointments and reappointments, although I tend to focus a lot on that. It's also about MOUs, the Memoranda of Understanding between the chair and the minister or the ministry. It's about reporting requirements, expectations, all these things. It's about building a foundation. That's what we need. We need this strong foundation where independence is such an essential part of that foundation, which is built by consensus. It's built by almost like a culture, a tribunal culture that's accepted by government, by the media, by the public, stakeholders, the legal profession, all these important players in the justice system. If we have this strong enough foundation that there will be consequences for anyone who wants to try and break that foundation, especially in terms of independence. We're obviously not there, and any progress we make can be reversed. So that's a huge challenge, to have that kind of strong foundation, like the courts. People don't tamper with judicial independence. We need to have that same respect. Tribunals are always like that, right? We get no respect. So we need to have that same respect for tribunals. Marion mentioned the word champion. What we saw over 1 decade, and I'm not partisan, people know me, I've been in the public service for 3 decades, appointed by all 3 parties. But what happened with the Liberals provincially, we had Deb Roberts. She's a Soar Medal winner, okay? That's an acknowledgement of how important she was in the development of a depoliticized, for the most part, depoliticized tribunal system in Ontario during those 10, 12 years. She was our political champion for tribunals. She understood tribunals. She valued independence. I'll tell you a little story. No, maybe I shouldn't. There's too many inside things. But basically, I recommended the non-reappointment of someone who was very close to the Liberal Party. It was done. It wasn't done. Luckily, the caseload increased and we were able to reappoint the person. but I had no opposition to that. I was bold enough to make that move because I was 1 year into my 5-year term. And would I have recommended that non-reappointment of a strong Liberal person if I was 6 months from the end of my term? I would like to think I would be principled enough to do it, but I can't tell you. That's the reality of the problem of independence. So when you have a political champion, ideally it's the premier or the prime minister, right? It can be the attorney general, as Marion had mentioned, those kind of examples. But having even someone, a political staffer, a senior staffer like Deb Roberts, that made all the difference in those years. And then who can advocate for tribunals and independence in the tribunal community? We see some of the restrictions of an organization, a great organization like SOAR, Society of Ontario Adjudicators and Regulators. It's filled with people who depend on the government for their appointments or who are staff in the Ontario government. So that has limitations. We used to have a strong circle of chairs. When chairs get together and they speak, the government has to listen. We haven't had that for a long, long time. And now with clustering, we're not going to have that anymore. So there are limits. That's why groups like Tribunal Watch Ontario have been established, and we're busy trying to fill this gap. CCAT may have a role federally, as a national organization, Council of Canadian Administrative Tribunals, to speak for each province in a way that does not threaten, perhaps, the members speaking out. Academics, obviously, having you, Laverne, and Paul be such champions as well. So those things help. In terms of the scope of the commentary, I'll finish off on this part. I think that my article talks about some of the areas that may not be mentioned specifically in the commentary. So, the impact of the lack of independence on the quality of tribunal members. How can you attract or keep enough good people when you don't have independence built in? The impact on morale, on collegiality, consistency. So, so much harder. If I were a chair or any members, so much harder to build collegiality, foster consistency, build a whole culture of tribunal excellence if, frankly, some of the members may not trust each other. Some members have connections, some don't. So that makes it very hard. I think principle number 1 and number 3 on the appointments and reappointments, they should be more explicitly linked in the document because they raise the similar issues of attracting or retaining good members. Back to reappointments, as one of my favorite topics, just to close off. I've said for a long time that reappointments should not have to go through the minister or even cabinet. Reappointments should just be completely removed from the political arena. The basis is there. This ADIGA, the Tribunals Act, requires the chair's recommendation after the chair's assessment of the performance of the member. What room is left for ministerial discretion, cabinet discretion? What room is left to refuse a chair's recommendation on the basis of merit and the operational needs of the tribunal? There is no logical room, but as we know, politics is not very logical, so I'll leave it at that.
Thanks so much, Gary, for all of those reflections. I really love the idea of building a strong foundation, thinking about the culture, that we need to promote and design and develop for tribunals to be well anchored and well considered and properly, their issues properly considered, and having a champion. And I think this idea of having a champion is, it's so interesting because it really calls into question, how do you find champions? I think that even the way that you've discussed this talks about how one would first look to government and expect that there would be a champion within government or somewhere, involved with government. And yet it falls outside of government ultimately to those who are like Tribunal Watch, playing somewhat of an ombuds officer role, if you come right down to it. So, thank you. I think those are such interesting comments. I have a few comments to add with respect to equity, diversity, and inclusion and the principles of independence and impartiality. I indicated at the beginning that I'm part of the Tribunal Watch Group as well, and certainly, I had a bit of a contribution in these principles in their drafting, but I think I'm still able to offer some reflections on what I see as the positive aspects in places where there's room for refinement. So one of the positive aspects, I think, when we think about equity, diversity, and inclusion, is that these principles, along with accessibility, are stated right in the preamble of the Statement of Principles. So if we go back to this theme of foundations that we've been, that's come up quite a bit, almost as a leitmotif throughout today's session, I would say that having those principles stated at the beginning serve as a foundation for the rest of the principles in the document. One perhaps critique that I would offer, though, is I think it would be wonderful if these principles were explicitly, if it were explicitly indicated that these principles related to and served as a foundation, or related to, simply put, all of the principles in the statement. Another thing that I appreciate about the statement is that there is a principle which deals specifically with accessibility, inclusion, diversity, and equity, principle number 5. And it indicates that equity, diversity, inclusion, accessibility will not only figure in the makeup and operations of the tribunal, but also figure into its decision-making. So this gives comfort in the idea that tribunals will engage in whatever work it takes to understand how impartiality enriched by EDI vantage points should be developed and used within tribunal adjudications, and hopefully addressing issues such as the ones that Marion has raised. So, enabling those who are using the tribunal to have confidence, public confidence that, in some shape or form, there are people who may understand their issues. So another suggestion that I have, and I'll end with this, is that it might be useful to recommend the use of advisory committees on equity, diversity, and inclusion, especially during appointment processes. So these committees might be able to assist with recruiting interested applicants, which I think is another area that's a bit murky when it comes to tribunals generally, and with respect to recruiting people from diverse backgrounds. So, we have about, we have fewer minutes than I thought, but we have some time to turn to our audience. And I want to look at some of the questions and see how we might engage with them. So let's see. I'm going to start with this question. Any thoughts about what individuals working within tribunals can do? We feel powerless on many occasions and frustrated to see how appointments work. It is also demotivating for members who are told to work hard and manage a busy caseload, and yet may not get reappointed given how the process works. What can we do? How do we prevent the best and brightest from leaving? So such an important question. And I think I'll turn first to Gary, to you, to see what you think about this question and what you might suggest.
Yeah, I mean, I've been contacted by people on the inside of different tribunals at different levels, federally, provincially, and it's a challenge when you have these kind of problems. And there are limits to, obviously, to what you can do. Sure, you may have whistleblower protection, but do you want to risk your job and your possible reappointment? You might want to say some things privately, brown envelopes. But again, why do we put people in that position? Members who are just trying to have a career to do justice should not be placed in these positions. This is the responsibility of people with power and influence. And so this is why Tribunal Watch Ontario was formed, to the extent that you on the inside feel comfortable reaching out ethically, discreetly, confidentially to others. Doesn't have to be us. It can be other trusted people in the legal profession, in government even. Those are the kind of risk assessments that unfortunately you have to make within the tribunal. Hopefully you can rely on a strong legal service. If you know, they don't report directly to the chair or executive chair. They have the security of tenure from being a permanent government lawyer in most cases. And so, you know, there could be a role there for legal to not to push, be able to push back. I would say something silly like unionize, but I won't go there. So really there are some limits, but it's obviously a difficult situation.
No, thank you for that. I don't know if anyone else has any comments. I don't know. Paul, did you have a response to this as well?
I can't improve on Gary's response in terms of what an individual adjudicator can do. In general, and this might respond to some of the other questions which are on the list. If we were to move to, where are the pressure points? The law on independence is all about the pressure points. The pressure point is your financial security. The pressure point is your security of tenure. Can you be fired? Are you going to get reappointed? And there's administrative autonomy. Another pressure point is the government going to cut our funding if we take decisions which the government doesn't like. On the security of tenure point, I didn't mention, I should have mentioned the situation in Quebec, where tribunal independence is guaranteed by Section 23 of the Quebec Charter of Rights and Freedoms. Now, this doesn't give you judicial independence protections, but it does give you significant protections in terms, particularly of security of tenure. In the Quebec Administrative Tribunal, the big super tribunal, their appointments are indefinite, subject to good behavior. That's one possible model. There are other tribunals in Quebec, however. There was a case about 10 years ago involving the Commission des Lésions Professionnelles, where the members didn't have Administrative Tribunal of Quebec protections in terms of security of tenure, but they did have, at the end of their 5-year mandate, an independent renewal process. So it wasn't that it was on the whim of government that they would be reappointed. There was an evaluative process, and that evaluative process was subject to judicial scrutiny for its rigor. And had the process not been sufficiently rigorous, the tribunal would have failed the Section 23 of the Quebec Charter test. Now, does that mean we need quasi-constitutional legislation in Ontario or in other provinces to protect tribunal members? Well, not necessarily. I mean, one could imagine Tribunal Watch or CCAT developing a policy, a sort of a best-in-class policy model for tribunal reappointments, whereby you would have an independent evaluative process which would feed into the renewal process. And that, if such a system were in place, that would help, I think, at the individual level too.
Thanks so much, Paul. And yes, I mean, I think that thinking about the the idea of fuller tenure, lifetime tenure, thinking about having, you know, perhaps a roster of qualified individuals from whom you can draw, some sort of process in place for better choosing administrative decision makers. Those are all things that I think are quite useful. Let me ask this question, and I'm going to actually shift now to the tribunal user perspective a bit and ask Marion, if we were to have a system where there was, tenure for life or tenure for longer terms, how do you think that would be received? I mean, I wonder about the the perceived advantages and disadvantages, perhaps of those from various communities, such as marginalized communities?
I think that the idea of security of tenure is a really important one, because as someone who appears in front of a tribunal, when you're before an experienced adjudicator and you're able to present your case and your client has that opportunity to be heard, that is what the hearing process is all about, right? And so it's so critical to that access to justice that we're all concerned about. When you have adjudicators that don't have that security, that you're asking them to interpret legislation, to take into context circumstances, to put them in context, to look at maybe rendering a decision that is really going to challenge a decision or challenge the government. You're worried at times as to whether the tribunal adjudicator is going to be able to render that kind of decision. So providing that security of tenure is speaking to their independence to be able to engage in qualitative adjudication. And let's face it, tribunal work is hard work, right? And so you want people who are qualified, who are skilled, who are going to make that investment and really work at this opportunity to render justice. So providing that security is a way of allowing them that opportunity to develop those skills and make that kind of commitment, where they're not always looking at the calendar going, well, I could be reappointed in a year or not. I better start looking for another work. What's happening politically? Because as Gary has said, this political climate is always changing on the federal and provincial level, and it has such direct impact on tribunals that we need to kind of separate that process, so we don't feel every shifting wind means now I'm not going to be reappointed. I think within the tribunal system, if you have that security of tenure, then you want to address that tribunal member development and that assessment process that happens through the chair to make sure that we see people who are actively engaged, and you don't have a situation where somebody says, oh, I have tenure, I don't have to do anything anymore, right? And so that would be the only caveat that I would see, but I think it is a really important concept to look at.
No, thank you. I appreciate all of those comments. And I see that in the chat, we've also had some comments. This is obviously, as I anticipated, a controversial question. We see people who are definitely on the side of no, who like turnaround for the, I believe, for the reason of having some fresh ideas. So certainly, certainly controversial, no definite answer. And I think, Gary, I think you were about to say something as well, if you'd like to weigh in.
Yeah, just to chime in on this, having seen Paul Adamant's comments that I generally agree with, but you're right, Laverne, this is a subject of no consensus, even within Tribunal Watch Ontario. We've had some great discussions. It deserves its own webinar and roundtable. I've gone a bit back and forth on this over the decades, but being a chair, and I always preface this as saying, I'm biased as a chair here. I cannot imagine managing a tribunal with lifetime members. I want to manage a tribunal with members with fixed terms and a rigorous, merit-based, credible process, depoliticized process for reappointments. So we can address the independence issue without giving lifetime security of tenure. And I think that's part of the promise of having these discussions with different people to try and build a consensus, try and figure out what that kind of system would look like. And just very briefly, having seen the question on performance assessment, which is a little bit related to this, you cannot have a merit-based reappointment system without performance assessment. So, again, there used to be talk decades ago about, oh, independence, how can you, judges don't get performance assessments. Well, we're not judges. So as long as we have reappointments, we need merit-based reappointments. And you cannot argue for depoliticized reappointments if you don't have some form of performance assessment. So that's how I would answer that one.
Yes, thank you very much for that. I think we're kind of caught in a situation where, I think ultimately everybody wants to have decision makers who are engaged, who are continuing with professional development, who are working to the best of their ability and integrity to make decisions, whether that means appointments of short-term, longer-term, or the longest possible term, a lifetime appointment. It's not clear, and how those performance assessments are done is obviously crucial to determining that the factors I mentioned initially are met. So I think, unfortunately, our time is coming to a close. And if you have placed a question or comment in the Q&A box, I can say that we have received it, and we appreciate your feedback. I think, though, that I need to turn now to thanking everyone. And this has been such a wonderful conversation. I've very much enjoyed it. So first of all, let me thank all of the guest speakers who participated today. It's truly been a pleasure to have you share your knowledge and your experiences, your expertise with our audience. I also want to thank you personally. All of you are colleagues to me from different contexts, from the university, from academia, and or from the tribunal community. And it's really been a pleasure to have this discussion with you, drawing on our respective perspectives and reflections. So thank you for that. Thanks to all of you who attended our webinar today. Thanks especially to those of you who contributed to our Q&A, and apologies again that we could not get to all of the questions. I hope that you enjoyed today's event and found it informative, and that you'll join us next week. So in a week, on Tuesday, June 1st, we have the second webinar in this webinar series. It's on tribunal competence and expertise, and we will have terrific speakers once again, some repeat speakers, in fact. And just to note that it starts at noon next week. And I finally want to thank our partners and sponsors. So our partner, Tribunal Watch Ontario, for creating the Statement of Principles and prompting this discussion. I also want to thank my home university and law school. So thanks to Windsor Law for generously hosting this event. And above all, thanks to all the people who have been so instrumental and involved in helping to organize this event. They've assisted me greatly. So staff from communications and law events, Rochelle Prince and Sue Arnold, my administrative assistant, Dylan Margerson, and my research assistants, Lucia Chiara Lamani and Dalal Hiji and Nadia Shivratan. So that is it for today. I look forward to seeing you all in some shape or form next week. And thank you once again for this conversation. Bye.
Bye. Thank you.